20 real estate test questions related to the practice of real estate and required disclosures. Now, I don't love this topic, but it's an important one. It makes up a big portion of the real estate exam. Another thing to note is you might actually use some of this stuff in your real estate career. So let's go to question number 1. An agent is required to disclose a death in the home if it occurred within A, 1 year, B, 2 years, C, 3 years, D, 5 years. Correct answer, C, 3 years. This one you probably will see in your real estate career. A lot of the times you will see death disclosures on properties. Question number 2. Which of the following is not a protected class under the 1968 Federal Fair Housing Act? A, race, B, religion, C, handicap, D, age. Correct answer is D, age. Race, religion, color, sex, national origin, handicap, and family status are all protected classes under the Civil Rights Act of 1968. Age is not a protected class under this act. I think you'll probably see this one on the exam or something related to the 1968 Federal Fair Housing Act. So get to know that one pretty good. Take notes on what each of these acts covers and does not cover. Sometimes it's easier to just remember what it doesn't cover, but you'll probably see a question similar to this on your exam. Question number 3, an agent advertises a property for sale for $120,000. When any potential buyer arrives for a showing, the agent says that the price has just been raised to $160,000. Wow, this agent really out here hustling. The agent is guilty of A, price fixing, B, false advertising, C, market allocation, D, blockbusting. Correct answer here is B, false advertising. So this is typically what's called a bait and switch. Going back to what I just said for question number 2, this kind of applies to question number 3 as well. Just make sure you understand what things agents are allowed to say and do, and what actions are not allowed or prohibited is the term you'll see a lot on the test based on these fair housing acts. Question number 4, how long does a landlord have to return the unused portion of a tenant's security deposit? A, 10 days, B, 14 days, C, 21 days, D, 30 days. Correct answer here is C, 21 days. Landlords must return the unused portion of a security deposit within 21 days of termination. So this one's pretty relevant in the real world, especially if you're a property manager. Question number 5, when working with someone other than a client, a licensee may A, disclose information that is public record, B, fill out a blank land deed installment contract, C, draft a deed of trust, D, refuse to cooperate with other licensees. Correct answer is A, disclose information that is public record. Make sure you know what agents are allowed and prohibited to do. Question number 6, all of the following people need a license to practice real estate except A, a person paid to solicit buyers, B, a property manager negotiating leases, C, a trustee selling under a deed of trust, D, a real estate assistant hosting open houses. Correct answer, C, a trustee selling under a trust deed. Just as a general rule here, any negotiating or soliciting for a fee requires a license. Question number 7, a contract in which something remains to be done by one or both parties is best described as A, bilateral contract, B, unilateral contract, C, executed contract, D, executory contract. Correct answer is D, executory contract. So I would suggest you know what each of these contract means and the responsibilities of each party in that contract. If you get a question this easy that you just need to know the definition, great. But sometimes they do ask a little bit more details of whose responsibility it is. So make sure you understand these contracts well. Question number 8, which act prohibits discrimination in housing transactions? A, the UNRRA Civil Rights Act, B, the Rumford Act, C, the Civil Rights Act of 1866, D, the Sherman Antitrust Act. Correct answer is B, the Rumford Act. The Rumford Act, found in California's Health and Safety Code, prohibits discrimination in housing transactions. So I recently passed my broker exam, and the way I studied for it was whenever I saw something with these acts, I would write down what that act was related to. So for example, the Sherman Antitrust Act, I know that's related to monopolies, right? They're going to have these keywords when you're studying and you're taking notes, or going through the chapter summaries, make sure you know what these acts apply to and the main reason behind them. Speaking of acts, question number 9. The Civil Rights Act of 1866 established which of the following as a protected class? A. Gender. B. Disability. C. Race. D. Age. Correct answer here is C. Race. The Civil Rights Act of 1866 prohibits discrimination based on race, color, and ancestry. So as I mentioned in the last question, I recently passed my broker exam on my first try, and I used a learning platform called Calibri. I used their CompuCram and their study materials to pass my exam on the first try. That's where these questions come from. If you want your own test bank of questions and test prep, there's a link in my description. Full disclosure, it's an affiliate link, so you are supporting my channel. I get paid a little bit if you decide to go through with it, but at the end of the day, I wouldn't put it there if I didn't stand by it, and I used them to pass all 3 of my exams: my salesperson's license, my loan officer license, and most recently my broker's license, to pass on the first try for all 3. All right, let's get back to studying here. Question number 10, which of the following could a real estate agent lawfully prepare? Oh, we had the opposite earlier. A general warranty deed. B, a lease agreement longer than 1 year. C, a land sales contract. D, none of the above. Correct answer, none of the above. And the reason is all of these documents should be prepared by an attorney at law, aka a lawyer. Okay, so we're halfway through the video. This would be a good time for you to review, see the ones you got right, check out the ones you got wrong, take a couple quick notes, go ahead, pause the video, get some water, come back. And now let's get through the next 10 questions here. Question number 11. What should an agent use as guidelines to determine if an action is ethical? A, the Fair Housing Act. B, the Real Estate Settlement Procedures Act, RESPA. C, Business and Professions Code. D, the Department of Real Estate Handbook. Correct answer here is C, Business and Professions Code. Every licensee should be familiar with California's Business and Professions Code, which provides suggestions and guidelines for agents. When I was doing my practice exams, I actually got this one wrong for the first time, but after I got it wrong, I wrote this down, and now I'll never forget that I need to follow the Business and Professions Code. Question number 12. A real estate agent owns a professional responsibility to the public to A, disclose a client's confidential information. B, file the deed to the county recorder's office. C, treat all parties to a transaction honestly and fairly. D, ensure the buyer gets financing. Correct answer here is C, treat all parties to a transaction honestly and fairly. Question number 13. A contract to sell rural properties requires which of the following? A, an appraisal. B, legal description. C, tax assessment. D, parcel number. If you don't know what these 4 answers mean, please go learn these definitions. That will help you pass the exam. Question number 14. Which law mandates how much a real estate broker can charge for commission? A, California state law. B, federal law. C, local association policy. D, there's no such laws. This would be a violation of the Sherman Antitrust Act. Correct answer is D, there's no such laws, as this would be a violation of the Sherman Antitrust Act. So the Sherman Antitrust Act prohibits both price fixing and market fixing in real estate. And this basically means all commissions are negotiable, and they always have been. Question number 15. What properties are touched and concerned with agency disclosure law? A, all property. B, only commercial buildings. C, 4 family units or less. D, 5 units or more. Correct answer here is C, 4 family units or less. So I personally got this question wrong many times. I used to think it was all property. But when it comes to agency disclosure law, it only applies to residential properties, which is 4 family units or less. Commercial properties, they're assuming that the buyers and sellers, the parties involved, are typically more savvy, and they are going to have their own legal teams. Question number 16. A real estate firm has an in-house title company, mortgage broker, and home inspection company under one business entity. They got it all, baby. This is allowed only if A, there's no duty to disclose these relationships. B, the consumer signs a waiver. C, control business arrangements are clearly disclosed to the consumer, and the consumer is aware that other providers are available. D, each service is optional at closing. So the correct answer here is C. Basically, if you disclose to the consumer and they're aware they can pick other service providers, it's allowed. Question number 17. All the following documents must be approved by the real estate commissioner prior to use except A, a listing agreement, B, a purchase agreement, C, independent contractor agreement, D, agency disclosure form. Correct answer here is C, independent contractor agreement. All those other forms, there are standard California Association of Realtor forms that most of us use. And so documents executed with clients pretty much just need to be approved by the Department of Real Estate. Question number 18. Which of the following transactions requires agency disclosure? A, the sale of a commercial office. B, the sale of a retail plaza. C, the sale of an amusement park. D, the sale of a duplex. Correct answer here is sale of a duplex. As mentioned in the previous question, every residential transaction requires the disclosure. Once again, commercial properties do not. Question number 19. Which of the following is a violation of the California Code of Ethics and Professional Conduct? A, puffing. B, offering a rebate with disclosure. C, telling a seller their home is worth more than it is in order to get a listing. D, refusing to co-list. Correct answer is C. Telling a seller their home is worth more than it is just in order to get a listing is a violation. Last question, question number 20. A salesperson presents a full price offer from a financially qualified black prospect. Later, the salesperson's broker presents a lower offer to the same seller from a white prospect. The seller accepts neither of these contracts, but sells to a neighbor through the same salesperson and broker, who decides to buy the house to prevent the black prospect from purchasing the property next door to them. Which of the following parties would not be subject to liability under the Federal Fair Housing Act of 1968? A, the neighbor. B, the salesperson. C, the seller. D, the white prospect. Correct answer here is D, the white prospect. No one is allowed to do discrimination. The neighbor, the salesperson, and the seller were all a part of this discrimination plan, and thus they are subject to liability under the Federal Fair Housing Act of 1968. The only person that wouldn't be liable is the other white prospect. They just submitted an offer. They had nothing to do with this devious plan. So yeah, make sure you know all these different acts and what they cover. And if you've stayed to the end, I got a nice little treat for you. I got a bonus question, question number 21. Alfred and Allie buy a 10-year-old home and have tested it for radon prior to closing. The test results in an average reading of 4.8 PCI/L. Under federal law, is the seller required to mitigate the home? A, yes, federal law dictates mitigation over 4.0 PCI/L. B, yes, if state law mandates it. C, no, unless agreed upon in the contract between buyer and seller. D, no, because radon mitigation is optional. Correct answer here is C. No, unless it's agreed upon in the contract. So there's actually no federal laws regarding radon mitigation, but the federal government does recommend mitigation on homes that test over that 4.0. But at the end of the day, it's up to the buyer and seller and what they agree on. So now that we've gone through 21 test questions, I want to thank you for studying with me. And if you could do me a huge favor, I love to see it. The other people that watch the channel love to see it. Drop a comment when you pass the exam.